Good afternoon, everyone. My second case in the sequence is S.R. Bommai versus Union of India. So, again, starting with the background, S.R. Bommai was the Chief Minister of Janata Dal government in Karnataka between August 13, 1988 and April 21, 1989. So, while he was in the government in Karnataka, during his tenure, several MLAs defected and joined other parties, leaving Janata Dal to be a minority government. Eventually, his government was dismissed on April 21, 1989 under Article 356, and president's rule was imposed in Karnataka. Back then, the practice of president's rule was a common practice to keep opposition parties at bay. So the grounds of his dismissal were that the government had lost majority following large-scale defections engineered by several party leaders of the day. S.R. Bommai then gathered all the MLAs back and asked the then governor P. Venkata Subbaiah to prove his majority back. The governor, despite receiving 19 letters from Bommai, refused to give him the opportunity and said that after some time fresh elections would be conducted so that a new government can be formed. Following this, Bommai went to the Karnataka High Court to challenge the government's decision, but the High Court upheld the governor's decision and dismissed Bommai's writ petition. Then S.R. Bommai went to the Supreme Court of India. At that time, coalition governments were forming in the country, and Article 356 was being misused very frequently by Congress government. One instance was that after Babri Masjid demolition in 1992, under the P.V. Narasimha Rao's government dismissed governments of 3 different states on no valid grounds. These were the BJP-led governments in the states of Rajasthan, Madhya Pradesh, and Himachal Pradesh. So yeah, that was the instance. And when S.R. Bommai took his case to the Supreme Court, it almost took 5 years to see the judgment. The issues raised in front of the court were that whether the president's rule inflicted in the 6 states at that time was constitutionally valid or not. Secondly, whether the president has unchained rules to proclaim Article 356 one of the Indian Constitution, and if yes, what is the scope of judicial review in this regard. He asked one issue raised in front of the government was that what's the meaning of the phrase that a situation has arisen in which the government of the state cannot be carried on under the provisions of this constitution used in Article 356(1). So these were the challenges in front of the court. So the arguments made by the petitioner was that firstly, S.R. Bommai was not allowed to prove his majority. Second, that the command of president's rule in the states was malified based on no compensation and was completely a political act. Just a little disturbance in an area does not provide any reason to force president's rules. Also, thirdly, it is the duty of the union government to duly present in front of the court all the information they have received upon which the essential satisfaction was taken and the president's rule has been imposed, which clearly they haven't. So under Article 74 Clause 2, Union of India cannot be discharged of this obligation. So these were the arguments made by the petitioner, and answering to those, the arguments made by the respondent, that is the Union of India, were that there is a difference. There is a difference in the nature and extent of the power of legal analysis in administrative and constitutional law. The definition of the current dispute is that whether or not Constitution has given preconditions for the exercise of power by the constitutional authorities, the courts cannot review whether the pre-existing conditions have been met. Also, secondly, if the powers are committed to a constitutional authority for performing a specific purpose, and if the relevant authority under the cover of achieving the said purpose uses the powers to accomplish an impermissible target, such use of power cannot be questioned. Also, on behalf of Indian Union, it was argued that only in the opinion of cabinet provided under Article 74 Clause 1 of Indian Constitution, a proclamation under Article 356 may be declared by the President, and an inquiry into whether or not any advice given to ministers by the President is just prohibited. Also, by subsection 2 of this article, the legal analysis of the reasons that led to the publication of the declaration is also prohibited. So these were the arguments made by both the sides in front of the Supreme Court. The judgment finally was that the court held that the exercise of power by the President under Article 356(1) to issue proclamation is subject to judicial review, at least to the extent of examining whether the conditions precedent to the issue of the proclamation have been satisfied or not. This examination will necessarily involve the scrutiny as to whether there existed material for the satisfaction of the President, that a situation had arisen in which the government of the state could not be carried on in accordance with the provisions of the Constitution. Also, the verdict also concluded that the power of the President to dismiss state government is not absolute, and the President can only exercise the power after his proclamation is approved by both the houses of Parliament. The formula of suspended animation was used, which said that you can only suspend the government for the time being, and meanwhile the governor of the state has to take all such necessary measures to restore the government back in his state. While the government is being suspended under the suspended animation thing, the governor must allow other parties a chance to form the government, and only if it fails, then also it must be dissolved and elections reconducted. Also, the court said that it has the power to overrule the proclamation issued by the President, whether it is approved by the Parliament or not, thus bringing the proclamation under the purview of judicial review. The court also supported the findings of Sarkaria Commission by endorsing the guidelines given in its report, including the issuance of warning to the errant state that it is not carrying on the government of the state in accordance with the provisions of the Constitution, along with procedural recommendations. Also, the court also reiterated that the secularism is one of the basic features of the Constitution. Any state government which pursues unsecular policies or unsecular course of action acts contrary to the constitutional mandate and renders itself amenable to action under Article 356. So this was the judgment basically given by the court in this regard. Finally, the conclusion of the case as such is that the case dealt with assessing the lawful mechanism and searching the whole area of constitutional imperatives on central state relations, and the contentious role of state governors upon calling the president's rule. The fact that under the system of our constitution, great power is discussed upon the center vis-a-vis the states does not mean in any sense that the states are little appendices of the center. The states are the greatest strength within the fields which are assigned to them. The center thus cannot and must not tamper with their powers. Thank you.